Hey, we're back with everyone's favorite Kirby Clements, back by popular demand. Everyone loved the last stream that we did. It got record number of views. I want to say about 3,000. And lots of comments, and I can't wait to see Kirby again. So I said, okay, well, let's get Kirby back in here. Not to mention, you're just a cool dude. And they said they loved our chemistry. So I was like, okay, well, Kirby could be a regular then.
Absolutely.
For those of you who don't know, Kirby and I met over a decade ago at CNN in Atlanta. He is a former Brooklyn district attorney. He is a current Atlanta area, obviously licensed in Georgia and New York, but he is an Atlanta area defense attorney. And he also partners with his sister at the same firm, and they also deal with personal injury law. Anything else, Kirby? I didn't go down the whole list.
But... No, that's it. I was also a Georgia prosecutor. I used to work in the Fulton DA's office.
Okay, so he has a lot of prosecutorial experience, so he can look at both sides of any given criminal case. And then in terms of the personal injury side of the practice, that falls under tort law. So tort law. So that is what we're going to be discussing today, which is tort law. Tort law covers everything from personal injury to defamation to anything relating to you being injured by another party. Okay, company, person, animal, whatever. Anything relating to you being harmed, whether it be physically, financially, professionally, by a third party or entity, is what tort law entails. Okay, so as promised, we were going to discuss it in the context of the Jonathan Majors trial. I had posted overzealously, of course, because you know I'm a drama queen. I like the razzle dazzle, and so I had posted and hinted around at, because we had through Twitter, through the different contributions I made on other people's YouTube channels, we had kind of played around with what legal remedies Jonathan would have after appeal. So keep in mind, he can't really do anything at this point until some type of resolution is met on appeal. They did say they did appeal, or they are appealing. They have until the 18th, because in New York it's 30 days. Right. So we have about 2 business days before they have to submit that appeal. So keep in mind, anything that we discussed today is under the lens of post-appeal, post-decision on that appeal, whether it's in his favor or not. He cannot take any actions against anybody from a tort standpoint until that is decided one way or another. Ideally, it will work in his favor, and then he can just go crazy, depending on what legal remedies he has. If it doesn't go in his favor, then he probably should just chill out. But he can still, depending on, what he's trying to go after from a tort standpoint, he might still have something to stand on, because it just like Kirby will explain to you, it depends on whether or not it's tied to what he was actually convicted of. Okay. Because if it can be proven to not have any merit based on what he was convicted of, then it's a frivolous lawsuit, right? Right. So, so we're going to let Kirby get into tort law. First and foremost, I guess we'll get into defamation first, because tortious interference, which is what I said I jumped the gun on, and I want to stick by that, because if I got my law degree tomorrow, I would be that attorney that probably people would call ambulance chasers, because I'm going for everything. I'm going to sue you for everything. Whatever sticks is going to stick. I'll have nothing to lose, right?
Right.
So my idea behind tortious interference was her confiding in his business manager, and then his business manager subsequently firing him. But we're going to play, once we get to that, we're going to play the scenario as if we know what she told her specifically, as if we know what the reason was she gave Jonathan. We're working under that scenario. And then going from there, what his rights would be in terms of suing for that. All right, but first we'll talk about defamation and whatever else you want to preface the conversation with, Kirby.
Okay, well, let me start off with this right quick. Just to put everybody in the framework as to explain what you just said at the beginning, legally, why those preambles have to be said. Anything that happens during the course of litigation, statements made during the course of trial in the courtroom, that's covered under the litigation immunity or litigation privilege. So you're not going to be able to sue somebody in civil court based on something they said in criminal court. And under New York law, there's a statute on it. It's absolutely privileged. So you could call me everything but a child of God and even be lying about it, but it's immune. There's an immunity issue there because we don't want to just engender needless lawsuits. I'm suing you for what you said when you sued me. Well, I'm suing you for what you said when you're suing me. So we don't have that. So there's going to be a litigation privilege or immunity. That's point number one. Point number two is if you have been brought to trial and as he was and were convicted, and then you say, well, I want to sue you for the false statements when you told people that I had done the things that I was convicted of. You told people before the trial that I punched you in the eye, and then the jury decides that you're guilty of that. Well, that's going to be barred by collateral estoppel. And what collateral estoppel basically means is we litigated these exact same issues in another court, and those issues were decided adversely to you. And as a result of them being decided adversely to you, you can't bring it up again. So yeah, the jury found you guilty of punching me in the eye. So you can't now sue me for telling somebody that I punched you in the eye because you are collaterally, that is on a separate track. And think of it like train tracks. If you got train tracks and a train's running on the track, those two tracks, the one on the right and the one on the left, two separate tracks, we'll call them collateral. They're running parallel, same issue, same train. But if one of them breaks, that whole train is derailing because think of it collateral estoppel. So you don't have a train running on one track. I mean, I guess the monorail, but that wasn't a two-track train. But that's the basic concept with collateral estoppel. So because he's been adjudicated guilty and it covers substantially the same facts, collateral estoppel will prevent a lawsuit. So those are the two things. Number one, immunity based on what's said in court, and collateral estoppel because a court has already ruled on these issues and you were found guilty. Next, we now come to, I want to jump to the last point that you gave. Can you be held liable for statements that you, even if you litigated them, that were addressed outside of court? Yes. Well, well, first of all, no, not if you litigated them because collateral estoppel will still cover that. But let's say she said other stuff outside of the courtroom. You've seen, lawyers give speeches and people say stuff when they're not in the courtroom. It's like, well, you said this, but it wasn't covered by immunity. You just made some statements that hurt me. And so I can sue you for that because there's no litigation immunity because these statements were made outside of the courthouse, outside of the courtroom. And as a result of them being made outside of the courtroom, it's free game for me. Conversely, you could, well, that's the big one. So here, back to the statements she made to his business manager, for example, beforehand. Let's talk about those. Well, we don't even know what was said. So that's kind of good for him to the extent that collateral estoppel would be asserted. Hey, she told her the same things you were convicted of. I don't know that until we get some evidence of that. Now, if we know on the front end, if the business manager had testified or if Ms. Jabari had actually testified as to what she said, and we knew what was said, then we can automatically know on the front end collateral estoppel applies. But in this situation, she didn't detail it. The business manager didn't testify. We don't really know. So what would have to happen is there'd have to be some level of discovery, depositions, or the like to find out what was said. Mm-hmm. What did she tell you? And if she said things that other than what was coming out in the courtroom, then there could be a claim that collateral estoppel does not bar those words. She could have said something horrific. He held a gun to my gun to my throat. He held a gun to my head or a knife to my throat. And it's like, okay, well, those statements were made to this woman they were not covered by the indictment. They were not covered by the trial. As a result of the fact that they were not covered by any of those things, I have a cause of action now. And you can bring that cause of action because it's not collateral estoppel, not litigation immunity. Those are the first point. But if you determine that they were covered, then he's barred. Now, as it relates to the appeal process that you've talked about, there's another interesting thing. Right now, he's blocked. You can't say anything. But if on appeal it gets reversed on sufficiency of evidence, that is, and that the reason I say sufficiency of evidence is because there are two types of reversals. One reversal, you get to go it again. You know, the court says, yeah, there were some mistakes made at your trial, and as a result of these mistakes, you know, we're going to reverse your conviction and you can be tried again. Well, at that point, they'll just strike up the band again, or he'll work out some deal. And that's one option to go. And that can foreclose, again, any litigation. Alternatively, if they reverse it on the basis of insufficient evidence, like we heard we read the transcript, we read everything that was out there. And based on that, that is not a violation of the law. Your conviction is reversed. At that point, now I would argue that one could then bring a claim, but the claim is not going to be predicated upon what she testified to because of the litigation immunity. So collateral estoppel won't bar it because a court has already said that was no good. But litigation immunity and litigation privilege would bar it, and that would block you from getting I'm sorry, it was the movement over here on my side of the fence. But litigation immunity would bar you in that situation. So we'd be focusing on the phone call that she made to that lady. What did she tell you on the phone? She told me, like I said, gun to the head, knife to the throat. That never came out of trial. Had nothing to do with, with the conviction being reversed. I'm going at you. And if it was just the same stuff that was said during the trial, she told me he broke her finger, he did X, Y, and Z. Well, we don't have a conviction, so we might not, we don't appear to have. And I can look up some more recent law to see if collateral estoppel would apply, but just based on the basic concept, they should not apply because, well, that issue hasn't been decided already. And so now, and it wasn't what was said in court because immunity stays with you forever, guilty or not guilty. So then we can deal with whether or not he has a claim at that point, which leads us to the next point that you asked about, which is defamation. Defamation, libel, slander, all of that is available to you to file, provided you don't have those two hurdles we talked about before. And you got to prove the falsity of it, which means you'd be back in a trial having to prove, again, I didn't put a hand on you. But the negative for him on that one is that the burden of proof is 51 to 49%. They don't have to prove beyond a reasonable doubt.
Preponderance of the evidence.
Yeah, it's just preponderance of the evidence. And so at that point, the jury's hearing, and you got to prove truth as the plaintiff. I did not touch that woman. And if the jury goes, well, I think he did something, you spent your time in a lawsuit and you'll be trying that same case over again in civil court, but you're going to lose. Just because of the fact that the jury is like, well, there's something, we see that what happened here, and it's entirely plausible. We can't blame her for not knowing when her finger got broke. But he
can also bring up the 3 times, 2 that we saw, 1 that she testified to that happened inside that we didn't see. That 5150 could go in terms of, well, it could have happened the 3 times that you grabbed my jacket, the 3rd time where you ripped the pocket off and the buttons. You know what I mean? So now we can say that's when the injury occurred.
I would suggest that his better suit would be not, because since they never addressed the issue of her attacking him, they never litigated that at all.
And did not allow the injury, the pictures of his injuries to be entered into evidence.
Ergo, we never litigated her assault on me. So if we didn't do a criminal litigation, there's no litigation immunity that's going to come into play. There's no collateral estoppel because you specifically kept it out and said, we will not bring that into this case. So he could still sue her. Forget the defamation. He could sue her for the attack that he says she did to him. I'm suing you based on what you did to me because the jury has already ruled on whatever they did. But once I get my level of justice, that is a court and a jury determines, presumably going in his favor, that you attacked me and you caused these injuries and there was no defense by you to what you did. Oh, you wasn't self-defense. It wasn't anything like that. It was just you attacking me.
Because
and he can bring that.
Phone. And this is in the transcript. She said she hit him in his arm, hit him in his shoulder. She grabbed the phone. She ripped his pocket, pulled the buttons off. She testified to this. And then we also saw it in the video. So there's no question as to what happened. She also got arrested. The detective that arrested her was on the stand, but they would not let him speak. Everything he said got objected to and sustained. So we have enough proof that he was injured by her, but they just refused.
Absolutely. And that gives you an assault and battery claim. And I will add this: the litigation immunity privilege, because I don't want people to think that it just whatever you said in court can't be used. No, you can't sue somebody based on what they said in court, but you can use what they said in court. So if she comes in that civil lawsuit and he says, I'm suing her for assault and battery because she assaulted me, and if she takes a stand, or he can rely upon, she testified that she did those things. So if she says, I didn't hit you, ma'am, the transcript, you admit to doing this to me. So it can come in as a statement by a party opponent, because he's not suing her for the words that she said in court. He's just using those words that were said in court to prove an action that happened outside of court. And therefore it would be admissible. As near as I can tell it, from looking at the law, as the way I went through it and looking at it, that would be, I think, still a valid claim right there. The interference as it relates to the business manager, again, we got Google reviews. Even if let's assume this, in the world that we are now, the conviction gets reversed, and we're going to go with it gets reversed on the basis of sufficiency of the evidence. There was not enough evidence to prove that he did these crimes to you. We're reversing it so he can never be tried again, because that would violate double jeopardy. Now he says, I'm now going to sue you, and I'm suing you not for what happened in court. I'm suing you for the words you told my business manager that caused her to drop me. And the business manager, now he's going to have to prove, you got to factor in damages and what lawyer would take the case and all those other things. But let's just,
and the kind of money that he lost. That's what I'm saying. Let's play the scenario that we know not that it was said in court, but we find out that Grace said this, and this, and that's why I was let go.
At that point in time, that's kind of like in the same realm as that you have Google reviews and Yelp and all these other reviews. If she says this was my experience with him, and this is my perspective of what happened, and I was relaying that to someone, I think that he would have a very tough row to hoe on that one. I'm using a Southern mentality, a Southern thing. I know your audience is bigger than the country folks in the South. So let me just say it would be a very difficult.
Northern New York and up in Syracuse, we hoe a lot of stuff up there.
Yeah, I get you. So, we hoe a lot of stuff. I'm gonna let my mind pause on that one, but I have a joke that's really, but in any event, at that point, I think if he goes and he says, she fired me because you gave these statements to her, and those statements were given with her with the intention of causing me some harm, he may have a claim. And I'm going to stress may. But if you're relating, if it was all fabricated, that is, you just lie. But I don't think, as I understand it, you're not going to be able to be sued for interference with business relations for somebody telling what happened. We had an encounter. He spoke to me and said some things to me that were harsh and horrible. I felt intimidated and I felt scared of this guy. All right, that may in fact be true. I mean, if you leave and I say, how was your service at, what's the guy that came through Atlanta just recently and just caused havoc? Keith Lee, so he comes in and Keith Lee. And I watch his reviews, because I love to eat. I've never been at the place. I go to the hole in the wall off the beaten track places, but I know this much. He gave a statement about his experience. This is what I experienced when I was there. This is how they treated me, and these are all my perspectives. Now, maybe it'd be good to put that in front of every sentence, but who talks like that? But I think the fact that her statements to the business manager would be in that same vein. Let me give you a review of my relationship with this man and how it's been. That person can then say, you know what? I don't like that guy. I don't want to do business with him.
I have a hard time with that, Kirby. I'm going to fight you on this. I'm going to fight you on this.
Go ahead.
The difference between Keith Lee, we know that's his job, that's his shtick. and he also documents it. He video records a lot of what he's doing. So these people know he's coming. They know what he's coming for. You know what I mean? And we don't have a contract with this guy. We don't come in there. I mean, the only contract we have would be implied that, okay, I pay you my money. You need to give me something in return for that money. But there's no contract saying that we have to have this wonderful experience and that if you pay me this amount of money, you're going to get everything, you know, ambiance, this, that, and the third. You're supposed to get your meal and a drink and get out. That's the only contract I have with you as a restaurant, right? Unless that fee that I'm charging you includes something else like a shoulder massage or, you know what I mean, a happy ending. I don't know. But if there's no other obligation on my end for your experience, then he can really say whatever he wants and kind of get away with it as long as we know that that's what his shtick is. In this case, she specifically says in her own words that I talked to her behind his back. Like she knew her intent was to talk behind his back with this woman about him. And again, I'm saying let's pretend like we already know what she said because she never said what she said.
No, I got you. I'm going to go with that.
Behind his back.
I'm going to take you with it.
With this woman.
Yeah, go. Which line you going to look at on that one?
Okay, so I'm looking at line 9. This is the first. Oh, wait, let me go back up because actually the first instance of her saying that this is the first instance of her testifying to speaking to him. All right, so starting at line 8, this is the defense. Was there anyone, because this was her saying that you see where she says that she didn't speak to anybody about their relationship.
Right.
She said she didn't speak to their family. And then prior to this, she said she didn't speak to any of her friends.
Right.
Then the defense asked, was there anyone you did speak with about the relationship? Who was that? His manager. Why did you do so? I felt I needed some support from someone who knew him, and I felt safe telling her all the facts without it being kind of, yeah, I felt it was a safe person to tell. Kind of what? A conflict of interest? Like, you know what I mean? I felt it was a safe person to tell because she also cared for him. And who is the defendant's manager? Her name is Priya Satyani. Why did you feel she was a safe person to talk to? Well, initially, that kind of openness within our relationship, me and her started because I would witness how he talked to her and I didn't like it. So to me, that speaks to intent because mind your business. Why was that the foothold for you to get in and start slandering this dude? And so I would offer her support behind his back. We would have these conversations and we could make this rapport, just kind of checking in on each other. Now, just to let you know, it has been established prior to this testimony and after, she exaggerates her relationships with people. She makes it sound like they have a deeper relationship than what they really do. And then when they come and testify, it turns out she hasn't spoken to them since 9 months ago. So when she's testifying to this, we don't know this yet. We're taking her at her word. And then as the days go on with her testifying, we come to realize, oh, okay, so you weren't really this person's friend. The first and last time you saw them was the night of the incident. This wasn't a long-term relationship. Oh, this person really isn't as good of a friend to you as you claim they are because they just testified that they ignored your calls for 3 hours and only called you back because you called them so many times. You know what I mean?
Yeah, but I'm going to say this. You go to a restaurant and your waiter or waitress or server gives you poor service and they have a relationship with that restaurant. They have a contract of sorts to work there and you complain. I didn't like their attitude. I didn't like how they did everything. They did that. They gave me poor service and now we don't know what poor service to you. That waiter or waitress is disciplined and or loses their job. So they have a contract, a business relationship with the restaurant that you have caused to end based on your complaint. Can you be sued? No. I mean, well, you could be, but you wouldn't win that lawsuit necessarily, or they might not win the lawsuit. In this instance, I don't think it matters. The relationship matters only to the extent that you're saying they interfered with the relationship, but you're still going to have to prove the falsity. There's no mind your business lawsuit. There is a you can't defame me lawsuit. And if you're telling these people I did something that I did not do,
right, and
I did not do at all, it's a lie.
And that's what we need to establish. That's what I'm saying. Let's say she did.
Then
she doesn't testify exactly what she told him. She's
in a post
talking to this lady.
I got you. So in a post appeal conviction reverse, insufficient evidence, not based on any evidence that came out at the trial, but just based on the statements that this lady says, and she says she told me X, Y, and Z, and the X, Y, and Z that she said is false. Then yeah, you have a claim at that point because you've made a defamatory statement about someone, period, or you wrote it, published it, or whatever.
He was beating on me. He pushed me around. None of this came out in trial. So this is stuff that she's saying just to kind of lay it on thick and get this lady on her side.
But now the question is, that's a trial you can have, but I process it like a lawyer. One,
well, yeah.
Well, I mean, I process it like, would I take that case? I'm like, unless she's rich and got some money, this is going to cost you money because you got to pay me by the hour. It's going to cost you a lot of money, and you're going to hope that a jury finds in your favor, because at this point, the principle does in fact matter, a la Johnny Depp, where you go, we need this win, whether we collect a dime or not, we got to have the win, because society has taught us that the best way to go is if you really didn't do it, sue them. And if you sue him, people will be like, well, you know, he did sue, and so that kind of shows us something. So the benefit of suing for him, whether he wins or not, is that he, assuming that the reversal and everything, all the other the precursors to this conversation, if all those precursors are met and he sues, yeah, he has a meritorious claim. He just may not prevail, or he may not get any significant money, but he prevails professionally. But if that lady comes in and says, you know what, I don't know what was going on, but even the stuff that he admitted in that interview, if she goes, you know, I heard this, I kind of figured that, and I just didn't want to be associated with anybody in that situation, that's not going to help her. So his claim would be, he'd be much better off on a straight defamation claim than an interference with business relationships claim, because then you're going to have that other person to say, you need somebody else to prove your elements. I need this lady to say the things that I need her to say. And remember, they didn't call her at the trial. And so since they didn't call her at the trial, I figure they didn't call her for one of several reasons. The main reason is you might give me some stuff that's helpful, but you might also give them some stuff that's hurtful to me. As a result, I don't need that at all. And that fact never changes. So it was so during the criminal trial, and they made a decision not to call her. And so it would still be so in a civil trial, and they would probably still not want to call her. Thus, I wouldn't go with any cause of action that would depend on her, because you don't know what you're going to get from her. Even with those statements, because it's not going to be, she said this, she said this, she said this, thank you, you can come down. It's going to be, give me the whole conversation. Give me everything. And is that what you base your decision on? As opposed to,
it's very possible that she was on the witness list. And that's what I was telling you earlier, is that they had a lot more witnesses than the 3 that they called. They only stopped it at the 3 because the Bellevue ER doctor that treated Jabari came earlier in the trial than they, as per their request. They assumed that he was going to be at the tail end, and so they had more witnesses lined up. But because he came at the beginning of the week, the defense specifically said, if we can get him on Monday, then I won't need the majority of my witnesses.
Yeah.
So she could have very well have been one of the witnesses, and they elected to call the agent instead of the manager because the agent established the timeline to kind of blow apart the story that she was unconscious when he arrived. She was not. She faked unconscious once she heard him come in the doors with the maintenance man, but she had been texting all the way up until 13 minutes before the cops arrived.
But think about this now. There is a concept in the law when it comes to impeachment. When that is impeachment, meaning this witness is testifying, and I want to either disprove what they're testifying to or give you some reasons why you shouldn't believe or credit this person like the other side is wanting you to. And one of those things is what's called a prior inconsistent statement. What that means is this person said something on the same matter, the same point before they testified today. So it's a prior statement. And that statement was inconsistent with the statement they're making today. Thus, I want you to know that this person, when it came down to the hitting, the fighting, the finger break, whatever, this person gave a different version before. And so you all can consider that as a prior inconsistent statement in order for you all to determine she's just making it up. Now, there's also a prior consistent statement, which is this person said the same thing before and they're saying it now. Now, obviously, if you're trying to claim that they're lying, you don't want to bring that in. And the party seeking to rehabilitate or make you believe this person again might say, y'all, they brought out what you thought was a prior inconsistent statement, but we got another statement that shows you she said it before. She sent a text message. She said the same thing. So only this one person tells you she said something different, but she's been saying this all along. So I mean, that's a rough concept of prior inconsistent and prior consistent. So for the defense not to call that woman says to me as well, or strongly suggests to me that she was not going to give them a prior inconsistent statement, because you would want that. I mean, I once tried a sex assault case against a teenager. I mean, represented the kid, and the girl she literally made 9 different statements about what happened. 9 separate statements ranging from he got her pregnant to, I mean, and to everything, all points in between, differing. And the allegation was he had taken off her shirt and touched her on her breast. That was not the statement that she testified to in court, but I basically had to bring out and assert 9 different statements of worse crimes that she said my client committed in that one transaction. Wow. Because it wasn't like he raped me to 8 different people. It was like, no, this is what happened. Another person, no, this is what happened. He touched me. And It was like, all right. So even though the statements that she alleged were all horrible, she never gave that out. So it was a gamble, but knowing what he was charged with, he couldn't get convicted of anything worse. So I'm like, I'll bring those out. So I can say this, that by not calling her, even though they got the doctor to bring up some other issues, and I appreciate all of that, but this person would have been able to give statements that were directly on point to the charges for which he was tried. And I'm going to presume convicted as well. Because she may have, let's forget the ones that he was acquitted on, but they didn't call her. So I don't have a lot of confidence that she would give us a prior inconsistent statement. And that's what I mean, is that she could have given us other stuff. She told us he did that and like 15 other things. And you're like, well, she's denied the 15 other things in court. We don't care about those 15 other things. We care about the one thing that she said. And the problem for us is she said it before and she's saying it now. So I'm just saying that person could be very damaging, and that might be the basis of not calling her, which is why I would think that the better course of action would be to sue her for the claims for the assault on him and what he did, because you can still kind of bring up the other stuff that happened here and just put it in context, except now we hear it. And if she gets convicted, then, everyone gets to see, you didn't just make this up. If we're going to credit the jury with convicting you, even if it gets reversed on appeal, because people aren't going to, I'll put it this way. Everyone goes, if he got reversed, we'd feel so great. I'm like, no, let's think about this. If somebody was convicted of child molestation and then they got reversed on appeal, who here would be like, that dude, he's all right. You'd be like, nah, they might have reversed your conviction, but you got convicted. So I'm just simply saying, in this scenario, his better bet, in my opinion, would be to litigate and go after her for the assault on him that the prosecution didn't bring, because that's clean. I'm suing you for assault. I'm suing you for battery. And he might throw a defamation in there as it relates to statements not made even during the course of the trial, because you just don't want to get messy. And you don't want the judge to say that you're relitigating the criminal trial and being able to kind of you can get jammed up in a way, because it'd be horrible to lose that trial where he's litigating that she made false statements. Right. You know, and the jury goes, yeah, we don't find for the plaintiff. Now you don't lost that. That's a huge gamble. Be better off with the defamation if you have to, but I would think just litigate the abuse, the assault, and the battery charge, and leave it clean.
Right. I don't know. I don't know, Kirby, because I'm like, why would the defense stick with this line of questioning if they didn't believe something else? So, like, looky here, where she says on line 9, what was the goal of being able to speak with Priya? I wanted him to get support for his temper. Okay, fine. He even said he had a temper. He said that in the audio.
So stop right there. Stop right there. Done. You said you had a temper. She said, I want help with the temper. Done.
Okay, but wait. Did the defendant, meaning Jonathan, learn about your conversations with Miss Sadiani? Yes. What happened after he learned about that? He was angry at me that I told her, as anyone would, right? Can you explain that to the members of the jury? Yeah. He told me that he had been open with her about our relationship and things that went on. So I felt safe to tell her. Why? That's his manager, his friend, not yours. Turns out, when I told her, she had no idea. So now you're implanting stuff. You're admitting to implanting stuff that she did not know. We don't know what that is. So I'm just using creative license and saying that she's saying a whole bunch of stuff. So then she felt she should tell him. So let's just say I'm talking to the manager and I'm like, well, you know, last week Jonathan pushed me down the stairs. No, what? Oh, wait, he told me that. You already knew that. No, I didn't. All right, I'll talk to you later, Grace. Jonathan, Grace just told me you pushed her down the stairs. What the hell is going on? You see what I'm saying? The court. So this is the judge. I'm going to stop there and ask that you, and then Ms. Galloway is the prosecutor, the ADA. Ms. Galloway, so she interrupts because she realizes it's going left.
Right.
Now the prosecution interrupts and she goes, Ms. Jabari, what did the defendant do in response to becoming upset with you? Because now she's trying to focus on him being upset instead of the fact that you're sitting here telling his manager stuff that she did not know about him. You see what I'm saying? So there was a lot of legal wrangling going on to try to distract the jury, distract us off the fact that you started talking to her and this lady did not know what you assumed she knew, because your whole thing is I started talking to her because Jonathan told me she already knew what was going on. And I was just talking to her because I figured because she knew everything, she knew the good, the bad, and the ugly, that she could, you know, kind of talk him off the ledge. When it turns out she didn't know anything.
But it's going to have to be false, is the point I'm making to you. He's going to have to prove false.
I don't know what she told her.
No, it doesn't. I'm saying no matter what she told her, he's going to have to prove that it was a false statement, period.
Or something that was not litigated.
Yeah, or not litigated, but even if it wasn't litigated and covered by the immunity, that's just a unique thing. I'm saying he's going to have to show that it was a false statement, period. You made a false statement, that is, I did X, Y, and Z. Like he pushed me down the stairs, like the example you just did. All right, I didn't know that he pushed you down the stairs. Doesn't matter whether she knew or not. The fact of the matter is, if it was a false statement, then you got a claim. But if he never pushed you down the stairs, then you have it. So it's not about making people aware of somebody's conduct or misconduct. It's not about making them aware of how bad it was or its impact on you. None of that really matters if you are not at the level of falsity. You have to prove falsity. That is, I can tell, Pepsi and Coke talk about each other all the time. Pepsi, McDonald's talk about Burger King, Wendy's has the best burgers, et cetera, et cetera. But the reality is, until you say something false, then you get in trouble.
Exactly. And that's kind of where I was going. I'm like, Jonathan, she said you pushed her down the stairs. What? No, I didn't push her down. What are you talking about? You see what I'm saying? This is, I'm building, like I said, I'm using creative license. I'm not doing a good job acting. I'm a good actress, right? I'm trying to build, the momentum for, again, we don't know. We don't know what she said. And maybe he did tell Priya stuff. He just didn't tell her what she told her. You know, so then that could be our basis for, well, what are you talking about? Because he didn't tell me this. He told me, and this is not stuff that came up in litigation and in trial. This is extra stuff that wasn't brought up. You know, I think you're muted.
Yeah, I am muted. My dog just got out of the I don't have my dog out of the fence. And we had some delivery guys coming by and he just started charging them. And I'm like, what's going on? And I'm seeing this dog in the front of the house. I don't know how he got out. Literally, I have no idea how he got out, which is problematic because he's a big dog. So
he's like, Daddy ain't paying attention. I'm out.
No, because they're gonna be moving some front day. We got new couches yesterday, and they're gonna bring them in now. But anyway, I don't know. You can edit that part out, but
oh no, you're fine. They like the real life stuff too.
Okay, well, hold on. Once we get past if we hit the hurdle of falsity, which won't be established even on a reversal, if the court says that evidence was insufficient, that just simply says what you said, accepting it as true, wasn't enough to equal a violation of this law. So a reversal on sufficiency of evidence is not the same as the court saying, in fact, the court will never say this. The court does not do a credibility determination at all on any of the matters. Hold on one second. I apologize.
No, you're fine, because I'm trying to find this place in the
So sorry about that again, but the life moves on. But here we go. So
no, you're fine.
I
just try to establish motive. Let's just say for the
you can establish motive, but again, you got to remember. Let's just assume that she actually had an evil motive. I want to ruin this man. That's my plan. I can't have you and all that comes with you. I'm gonna do the next best thing is make sure you don't have it either. I'm gonna shut you down. So I can't have it. You can't have it. That's her motive. I'll give it to her 100. Let's just give it to her. That may be true. And even though that's the truth of the motive, the fact remains that it doesn't change the fact that he has to be false. You can have all the malevolent intent that you want. And the law is like, we got people who have short tempers. We got people who deserve the wrath of a scorned woman. We got people who don't deserve the wrath of a scorned woman. We got all of that.
Right.
But that's just, or a scorned boyfriend or whatever. That's just par for the course. And they can trash you. They can say all the bad things about you they want until it gets to the level of false. At that point, it's actionable. So, I mean, the only thing you can say about somebody that's true, that's actionable, is if in the revenge porn situation, when people are like, well, you sent me some naked pics, so I'm going to post them online. Well, you didn't make those pictures up. Those are legitimate pics. You can literally tell people this, you find out that your significant other starred in adult films and you found the adult films that nobody knew about. I can tell the world about that. And there's nothing false. It's nothing, it's just dirty, it's low down. But the reality is, unless it meets the criterion of revenge porn, which is probably only going to really apply when you're talking about private relationships. Other than that, you got no real hope. Hey, he put online a video that's online. Well, I'm sorry, you did this publicly, sold your rights, and people just now know about it. No cause of action. Right. You tell folks somebody is dirty, low down, rotten, a cheater, a scoundrel. You could say whatever you want. But once you go from matters of opinion into matters of fact, he's a horrible person.
Right.
Perfectly fine. He's an evil man, in my opinion. Well, we don't have an objective standard on evil, so I'll take it. He's an evil man. He's all of these things. You know what? That's questionable. We'll deal with it. Hey, he's so evil that he put a gun to my head. Well, what? I don't even own a gun.
Right.
Boom. Caught with us. Hate to use the boom, but you have a cause of action at that point.
Unintended.
Yeah, pun intended.
Right. So that's the game I'm playing. I'm playing a long game. I'm playing, let's just say, because again, we won't know probably ever, but if it should get to this point, she might just come out. She might even just, write up an affidavit saying what was said. And if it turns out it was nothing that was testified to during the trial, and it can be proven that it was not true, boom, we got, and she says that this is why I fired him or dropped him as a client. Because at the end of the day, he probably could care less that she dropped him. But the professional ramifications of someone of her status dropping you makes you a pariah to other managers. You understand what I'm saying?
I think that, and that's why I say you should sue her anyway for the abuse that happened beforehand. Because even if you got, we just got to, I like to think pragmatically. And this is what I mean by that is, where are we at right now and where do we want to be? He wants to be employable again. He's a great actor. I've seen his work. I loved him in Loki. I've seen his work, and he's a tremendous actor, actually, a tremendous man. I never knew who he was until I saw like his SNL appearance. I'd never heard of him before. Then I was like, this brother really is doing great things.
Oh, don't say that.
Yeah.
Not on Martin Luther King Day. Don't say he's doing great things.
Well, look, I'm just saying, at least in his profession, he's doing great things.
I think so too, but hey. I think you froze.
Yeah, I know my screen is.
Okay.
Sorry about the screen freezing. But what I will say is this: is that I think pragmatically, what he should do is litigate her assaults on him, because at that point he gets justice, and people get to hear the stuff that they never got to hear.
Right.
Hearing an interview on whatever, and people can always criticize that at the interview, but it's like, no, let's bring her in or interview her. But better yet, I'm going to sue her. And then even if he dismisses or if, whatever, it's a gamble. But if he's like, she assaulted me and she's admitted assaulting me and I'm going to sue her, and maybe he wins on summary judgment, which is like, we ain't got to go to trial. A judge, upon hearing everything she said, goes,
that's right.
Liability is established. Ma'am, you did it. We're just having a trial on damages. Well, at that point, that's a win for him, because he's been able to say, I get that a jury convicted me of these low-level misdemeanors. They're very low level, and of accidentally doing something. And I get all of that.
In the process of trying to escape your psychotic activities. And
and the prosecution didn't even charge her as they should have with the crimes that she's admitted committing against me, as we see by a judge. But we now see the two standards of justice that happen in America, not just for blacks and whites, but also for men versus women. Because you'll see many more men convicted of assaults against women when you got plenty of women assaulting men. All the time in public. He's getting slapped on the face.
That's usually how a lot of the domestic violence situations start. The woman usually slaps the dude or throws something at the dude, and he doesn't exercise appropriate self-control, and he just goes in on him.
And that's what I'm saying. And domestic violence is a spectrum, because I know there's times when people do actions because you got guys who just half women murdered in America are killed by their former or current romantic partner. So men kill women regularly. And they're attacking. I can't get your phone number. Boom, you're getting attacked by some crazy dude. Then you got the incels. So you got a whole bunch of stuff out there. But if he's able to get a judgment, well, I'm just saying you got to cover the thing, because the incels like no woman will even sleep with me. So I want to kill all women. I'm like, well, bro,
because you're a weirdo.
if you reverting to violence over a no, that's probably why you got that no in the first place. But she could see her death in your eyes when you said, hey, what's your number? No, you are a killer. But I'm just saying we understand that spectrum of domestic violence. But what I'm saying is that he too can bring that to light, that domestic violence it's not just a man beating on a woman, it's a woman beating on a man. It's toxic relationships. And maybe our relationship was toxic, and we did have we had a toxic relationship. I can own that. But what I can't accept is that she gets to beat me without without any recourse, and I can't flee or resist without being charged with a crime. Maybe I do got an ego. Maybe I shouldn't have said be like Coretta or Michelle Obama and I'm a great man. Maybe y'all have an issue with that, but that doesn't change the fact that she has admittedly hit me. Police investigated and determined that she did. And if you're not going to bring her to justice, I'm going to bring her to justice, and I won. And then now we've got those two competing narratives that are in the waterway, and with those both in the waterway, because I can't unring the conviction bell. So with those both in the waterway, we're in, both bloods in the water. We got something now. Hey, look, I know you feel this way about me, and I got to do some off-Broadway stuff to kind of work my way back. And I mean, I have a whole plan for how I would, I tell my clients all the time, they go, what am I going to do? The ones who end up having to take a plea, because I actually win a lot, but the ones that have to take a plea, I tell them all the time, I can give you a plan for how to explain this away or make it not be so bad, because the story you tell is the one that gets told. And so we're going to come up. We're not going to deny we're not going to lie, but we are going to put it out here in a way that lets people go, okay, you're not the boogeyman that I associate with that crime.
Right.
So there's a way for him to get it back, but I think the way for him to get it back is to sue her, not for defamation or defamation for anything said outside of court that wasn't true.
Right.
But for the assault and battery that she's admitted to committing, and going that way, and then saying, hey, look at what we got. And then if he gets a win on appeal, I mean, this can happen while the appeal is going on. If he gets a win on appeal, that's a double win.
The cherry on the top.
Yeah, exactly.
Now, for the audience, what type of tort law is what you're discussing in terms of suing her for hurting him? What is that called?
Hold on. Am I unfrozen?
Yeah.
All right, hold on. It's going to freeze one more time. I apologize. Hold on. If I see what's happening, I got to plug you in. So give me a second.
All right.
It worked?
Yes.
All right, cool. So
what area of tort law is the one that you're discussing in terms of him going after her for what she did to him, the physical assault?
Oh, that's just right. That's just regular tort law. Torts are, let me explain this. You have criminal law, which is a crime is a violation of a law by the state. So the state or the government will always be the plaintiff. So if you look at it, it'll say the state of Georgia, state of New York, state whatever, versus the defendant, the actor who did it. But that's because you violated a law. Even though there's an actual victim over there, you punched Popeye punched Bluto, and Bluto's suing Popeye. Okay, but it also happens to be a crime. So it'll be the state of, whatever, the state of Cartoon Land versus Popeye the Sailor, and Bluto is the witness, the complaining witness. In a civil action, it is you committed an act that violated a right, and you owed a duty not to violate that right that I have. And by violating that, it's just me. That's just tort. That's just the overall category. Then you have different types of torts. You can have a business tort, which is what you were talking about with the tortious interference with business relations. That's a business tort. But you also have the individual personal torts. It's assault and battery. It's defamation. It could be discrimination. If your job fires you because you're a woman, sexual discrimination and all those are all personal torts that arise under some statute, and some torts just arise out of common law, or they just developed over time. Right. And then now they have a statute that tracks it. But that's the basic principle. So this would just be your basic, individual tort.
Okay, nice. So he does have a remedy, y'all. And I don't care what Kirby says, I'm still sticking with tortious interference until I hear from Priya Sadiani saying that what Grace said was true. I feel like she lied about a lot of stuff just to get that lady's ear. And again, I'm talking from the hell hath no fury like a woman scorned mindset, and from what I saw in her 3.5 days of testimony with her behavior, all the contradictions, the lies. A lot of people have a problem with the defense during closing summations, calling her a liar several times in that hour. But that's really what it boiled down to. She is a liar, and she lied many times on that stand.
I'll tell you what really got me is when the prosecution chose not to charge her. This is the one thing that really bothered me, because sometimes you have both sides if your two witnesses have a criminal charges where they're each the victim of the other, they each have the Fifth Amendment right to not testify.
Right.
And now if the prosecution, now you can waive it and testify, or the prosecution can make a determination as to what to do. The prosecution made a determination even before the police decided that she had done a crime, that they weren't going to prosecute. So they basically said, we're going to give her absolute immunity. You ain't got to invoke your Fifth Amendment. We're not even going to charge you with the crime, which I do have. I mean, I've done that, and I understand that as a prosecutor. When you're talking about, I got a more serious crime compared to a lesser crime. This person slapped you, but you shot them. I'm not tripping on a slap. Okay, they shouldn't have slapped you, but there's no way on this planet I'm letting you walk away for shooting somebody. Right. But if they slapped you and you slap them back, and I'm going to charge you with we need to charge everybody. There needs to be some equity in that situation. And that's the thing that bothers me, because I wanted to hear, and maybe they've already articulated it, but I would like to know, why did you determine that the police shouldn't be believed in this instance? That's the first thing I want to know. Why did y'all make that determination?
Well, I'm going to tell you what they said. They said that, okay, so the incident happened on March 25th, 2023. He did not file his police report, complaint, whatever you want to call it, until June of 2023.
Okay.
So they said it was
retaliatory.
Yeah.
Oh, but that's the point, is that the stupidity of that statement is as follows. And I can also show how it makes sense. But and this is the basic principle. If you determine that it did not occur, then it's fine for you to say this was a retaliatory warrant.
Right.
It didn't happen. You made it up. I'm not going to go forward with it because it's retaliatory. If, on the other hand, you're like, no, that too happened, and while I think that you're telling me in retaliation for them telling me about you, it doesn't change the fact that it happened. And there's no legal principle of the first one to the police is the one that wins out.
Right.
So that's what I'm saying, is that if they said, so the retaliatory sounds great, but I always go, you say retaliatory, but do you mean retaliatory and false? Or it's like, I was willing to let mine go because I thought this is what we do. But instead, you're going to prosecute me for what I did, then fine. We need to both be in anger management or whatever we get sentenced to.
That's fair.
And that's totally fair. And for them to not, and when the police concluded that it was true and made and charged her and made the arrest, when they made that conclusion, you've jumped over the retaliatory aspect of it, because it's like, it's retaliatory, but we investigated it and we found out it actually is true. Great. Well, we don't want to go forward now because we are now picking which of you two we want to go after. And my question becomes, why did you pick the man? Why did you pick the black man? Well, I don't know if it's because he's black, because he's a man, because he's a black man, because she's a woman, and you just felt like we want to say, I don't know why you picked, but based on what we know right now, with the truth of, let's presume all of it's true. If we think it's all true and we presume it's all true, why did you make a preference? And you can't explain that preference to me right now on any legitimate basis, because you didn't think you could win, because you lost some charges on this one. You didn't know you could win this case. So that can't be the basis. So when you start going through it, you ultimately go, what I'm getting here is you decided to try him because you didn't go after her only because he told you what she did after she told on him. And that's all I'm getting from you. And that's not enough. Right. And so that might smack up equal protection violations, but I think it has to be a little more broad based. Equal protection, meaning no one should be treated differently than another person on account of their race or sex. So in this instance, I only hear racist or sexist reasons to not go, because the same police that said he did this said she did that. And I think didn't she admit it?
She admitted it.
That's what I'm saying.
She said she did not recall or did not scratch his face or his forearm, which the pictures indicated. And the metadata supported the date and time that the picture was taken. So it was taken within a couple of hours of the incident. It wasn't later on or another day.
Which still not a problem.
But she did admit to hitting him on his arms and his shoulders. So
it's look, that's more valid than I don't know when my finger got broke. So,
Right.
you don't know when your finger got broke, but you definitely know that you did this to him during that time. That's what I'm saying. So when you really look at it, I get how you do ride hard for this man. And I get it. You are, if I ever get in trouble.
I ride hard for all black men, especially innocent black men.
Right. And I'm with it. If I get in trouble, I'm gonna be like, Daddy, I need you to be out there leading the forefront.
You, Kirby. I've known you for a decade. You always got my back. I'm a ride for you.
But having said that, I look at this one and I go, when I start asking those other questions, I'm like, see, this is a problem, because she should be sitting in, on trial herself, or shoot, she might plead guilty. We don't know. I mean, granted, they probably not gonna be able to use her statements against her because of, whatever statement she made in court, because they were made because she had been compelled to testify and they made a decision. But they could still prove the case without her statements, and he can still sue her. And I think he should sue her. Heck, I think he should probably file a claim against, let a judge throw it out. But I'm gonna talk about you like a child of God, like you're not a child of God. Like, look, you a racist, you sexist because you picked a woman over me. Same fact, she's admitted it, and you didn't. I'm putting it all out there so that, and then Hollywood is firing me because you know what? These are the same people that, when the black person is on the front of the marquee, when they take it overseas, they reduce the black person. So don't tell me y'all are doing this because you can't stand the idea that I was alleged to commit violence. No, you can't stand the idea of a black man, period, because you diminish us when we're major role players in your Marvel films or whatever film they have to be in when you go overseas, when you go to China, when you go to Eastern European countries. Suddenly you got the black guy in the background. What happened? I thought he was a co-star. So don't tell me it's about that. You are willing to throw us down every single time, but who do you stand by? And if we want to have this, let's have it. Because what's he got to lose?
Nothing at this point.
I mean, and not only does not that he doesn't have anything to lose, but
in the context of what we're talking about.
Yeah, in the context of what we're talking about, the facts are there. He's not making these facts up. These are facts that have already been established. She's admitted to hitting them. Yeah, so we got all of these things, and it's just like, but look at the double standard. So, and it's just like, hey, look, even if you tried her and she got convicted and didn't acquit me and I don't win on appeal, at least justice was done, and we can all go, well, you know what? Everybody who needed to get spanked got spanked. But in this situation, that ain't happening.
Right, exactly, and that's all it's about. It's about what's fair. It's about the gravity of what he was at, because I think we discussed it the last time we talked. It was actually 8 charges that they got him with, and then the first day of trial, the prosecution dismissed 4 of them, and then combined the assaults and the harassments.
Right, and harassment is a B misdemeanor. I think it's a B misdemeanor like that. Like that's nothing, and that's certainly not anything to be kicking anybody off. I mean, hey, what's Alec Baldwin charged with? I mean, didn't he?
Shooting somebody. Now it was accidental, but
I mean, hey,
lady dead.
I mean, I can go back. Ted Kennedy and Chappaquiddick. I mean, I can go through so many different things and come up to the point, and then I go, but here we got this man where the woman says I attacked him too, and you're like, and I don't know when I got hurt, but the video shows me attacking him as well. But just know this. He did something to me, and they're like, my gosh, he did. Right. And he's gonna pay. And you're like, wait, what happened? I would say what planet are we on? But I'm like, we on planet Earth, like we always been.
But that was literally the reaction of most of the people. I don't even think the reporters believed what they heard. Even the ones that were all the way along slandering him and saying I think we all were just like, what?
No, absolutely. I mean, but when you really have no shame like that, you kind of got to go, wait, like, but that ought to tell you something about where we are in this country, just in general, where now folks don't have to hint and go, y'all know what's going on. And only certain folks like, yeah, I know it. It's like, what do you got your other friends? I don't see anything going on. This is one where you're like, bruh, look at here. And it's like, yeah, I am really hard pressed to tell you that was not an unfair double standard right there. And it's like, yeah, but they did it openly, notoriously, in front of everybody's face. And that's because we're at a point now where we're real comfortable with doing that. We are real comfortable with doing it.
That speaks to the political climate we're in. That anytime you can just literally see everything for yourself and still get a complete and total
where they admit it. That's the other part, is where the other side is admitting what they did. You're like, well, look, it's not my perspective. They admit it. And we're like, yeah, that's true. But ignore them. We're coming for you.
It's like that scene in The Wizard of Oz when he goes, pay no attention to that man behind the curtain. Like, I see what's going on here. You're not a real wizard.
Exactly.
But I'm like I didn't just see you back there playing with the whole thing. Like, it was crazy. It was crazy.
No, it really was. But like I said, that whole thing about retaliatory, I'm just like, okay, well, we did that when I was a prosecutor. I would dismiss cases. I'm like, that's retaliatory. You just filed a complaint. But it would always be like, oh, she did it to me. And I'm like, okay, when? What happened? But in this instance, we're like, yeah, it's retaliatory, but it was also investigated. And after investigated, found to be credible and true. I never had that scenario. So when I have that scenario, I'm like, we would dismiss. I would do the mutual dismissals. I would say, hey, you got a fifth
charge or everybody goes.
Yeah, I would bring them. I get their lawyers. Get you the public defender. Public defender come in. You got a private lawyer. Cool. Is your client going to waive the fifth and testify against him? No. Is your client going to waive the fifth, testify against her? No. If y'all both sign off on this, invoking your Fifth Amendment rights, I'll let y'all go. And everybody signed and everybody went. And then there were other times where I'm like, no, sir, you've been beating that woman and you going to jail. And I didn't have a problem with it and won it and had no problem sending them off. I'm like, bro, that's what you need to be. Put your hands on a woman. And I prosecuted women I have prosecuted women for attacking men.
Right. I mean, it happens. We know, like you said, it exists on a spectrum. This is probably on the very low end of that spectrum, like before it even gets on the grid.
Yeah, this was very low end, and they were just in a toxic relationship. I mean, he had ego issues, and she knew how to feed into that. I'm pretty confident that she made him feel like king of the world because she was enjoying the ride, the luxurious ride that she was getting.
And she testified to that, Kirby. She said that she was his cheerleader. She used the phrase that she felt responsible for his what did she say? Mood, responsible for his triggers. She used a lot of words to try to make herself sound like she was his little puppet, which was BS. But the ABC News special that aired this week, he did say that he has been diagnosed as severely depressed, and he's had suicidal ideation since childhood. His mom, just so you know, is a mental health professional and a pastor. So this has been documented since childhood.
I have no doubt about that. I have no doubt.
She also manipulated that because she also testified to the fact that she would talk him off the ledge, and then he'd be like, "I'm good. I'm going to see my therapist." That's
why I say toxic. I think, some of that was she testified to
his mental illness. She kept poking the bear. She knew what to say, what to do, how to get him going, and then I feel like toward the end, because I did create a timeline of the different times that he broke up with her per her testimony, in addition to third-party information. He broke up with her twice prior to that final incident. And I think she knew toward the end that, oh boy, the gravy train is about to derail.
Yeah.
Let me, you know what I mean?
Oh, no, I get you. Now, I will say this, though, and to be completely fair, I will say that some of the language that she used is consistent with women who are in abusive relationships where they tend to blame themselves for, because what happens is they get to the cycle of violence. The guy erupts, there's something happens, he beats you, screaming, whatever. And then there's that honeymoon phase, he love bombing you, everything is going great, vacations or whatever. Then it kind of gets to where it gets kind of tense. And it's just like, I know it's going to happen. And rather than waiting around for him to get triggered by God who knows what, the woman will do something that she knows will trigger it. He always beats me when the food is cold. So I'm gonna make cold food, and then I just got to get it out the way because I don't want to be thinking. I don't want to go to sleep and then wake up getting my butt kicked. I'd rather just know it's coming. So that is the cycle of violence,
but and that does what to say though. That's that whole Darvo thing. It's the whole you had how many months to prepare for this? 6 months. So, I mean, at this point, she's trying to peg herself as a poster child for domestic abuse survival. So,
yeah, no, and that's why I say is that I chalk it up to a toxic relationship between what appeared to me. I'm not making a factual statement. I'm just making an opinion, purely opinion. It appeared to be a toxic relationship with someone who had some emotional issues, him, and some control issues, which were brought on by those emotional issues, and some insecurities, and maybe some grandiose thoughts, which are contradictory, but nonetheless can exist simultaneously. You have delusions of how awesome you are, but also questions.
But he is awesome. You even said it. So
oh no, he's a phenomenal. I tell you, he's a phenomenal actor. I mean, you feel it in his roles, but I'm saying he may have that component of I'm awesome, and then another component of imposter syndrome, and I don't know why I'm here, and anxiety about it, and those lead to some stuff going on. And then she has, her issues of, self-control, anger, alcoholism, and the like, and maybe her own anxiety issues. And you put people like that together, and it's like, man, it's not oil and water, man. It's gasoline and some Flintstones. When you shake it up, something's going to spark, and then there's going to be an explosion. But it's like both of y'all were explosive. Right. I just don't know who did what to whom. But my general take on this was they were in a toxic relationship, and they would just kind of navigate toward that edge, and then lines were crossed. And who crossed the line and why they crossed the line, and did he do X, Y, and Z to her? I feel like he probably did. My Kirby take, I think he probably was an emotionally abusive person and a verbally abusive person. And I think that she was also a physically abusive person. Like, you can use your words to hurt me, I can use my hands to hurt you, because the reality is, if you put your hands on me, you're going to go to jail. And so she took advantage of that. And except now the brakes came off, and it's like, well, you know what? I'm going to say this. And then, Lord, it happened to him. And I just tell dudes all the time, and I tell my clients when they're out on bond, and this is my advice to all my male clients when they're on bond, I say to them, you're not going to break up with your girlfriend. You come home, and your girlfriend comes home at 2 a.m, smelling the liquor, wearing another dude's t-shirt. You're going to be like, hey, baby, take a bath, hop on in the tub, because you can go to jail. Now, when y'all leave, when it gets to a point where you can go. But right now,
you need to play.
You break up with her, it's going to be a phone call, and you going to jail, because she's going to be like, he did X, he did Y, he hit me, he did whatever. So you got to walk that line, and like I told you, breakup law. You got to have somebody.
Right. I'm telling you, we need to do that, Kirby. I'm telling you, that would be a good. You think it's funny, but a lot of people in the comments said that's a good idea.
You just got to get.
It's a good idea. It could be like a side shotgun to divorce. Divorce, that could be your.
Right.
Do you need a breakup attorney too? Do you need us to? But
a breakup consultant. That way you can do it. Breakup consultant. I'm not giving you any legal advice. I'm just going to try to show you how to get yourself out of here, get your cameras installed, get everything squared away so you can get stuff on. And then when you say, hey, it's time for you to go, and they're like, oh, he beat me. No, baby, we got cameras up in here. I done videoed the whole breakup. I got friends here. I had it covered. You got to come up with something that happened a while back. And trust me, when we're breaking up, I'm going to get you to admit that I never put hands on you before. Like, baby, I ain't been wrong. We've had any big issues? Nope. Never no violence. No, nothing. I'm going to get you to say all that. Then I'll be like, great. Now I got you to say all that, baby. It's time for you to go.
Right.
Be gone.
See, it's funny you say that when you were giving your assessment of his personality, because he actually said the majority of that during the ABC interview. He said that he's a very emotional guy. He said that he had anger management issues. He said that, funny you should say about if she comes home smelling of another dude, I'll just run the bath and I won't say anything.
Right.
Because he did say that during the ABC interview this week, that when she asked, well, why didn't you just break up with her? He was like, he was scared. He said he was scared. He said the whole thing about the toxic relationship. He didn't elaborate on why he was scared, but I feel like it was in the same vein of what you were saying. Like, okay, if I break up with this chick, she done did this, and this. I already know she's talking to my manager. I already know this. I already know that. What else is she going to do?
No, exactly. I know that you're not going to physically hurt me, but I know that you're the kind of person that will do some stuff. And it's just really real, where you get to know somebody. Like, some people, when they go through a divorce and their spouse flips the script and does all this crazy stuff, they're like, I never knew that was them. But other people are like, no, that's exactly who he is. Like
And I
some
don't
women
know
will tell
how to
you,
get out of
I'm gonna
this.
divorce this guy. He's gonna come for me. Why? Because he don't like to lose nothing. So I
Mhm.
fully understand his point of being afraid. And I have advised people who were like, man, I'm going through this. How do I get out? I've talked to people and I've been like, look, man, I get what you're saying. So this is how you're gonna have to do it, man. You know, just so that there's got to be witnesses there. I mean, I had a client who told her he was breaking up with her and had already moved his stuff out and was just like, look, we're broken up, and was going down the steps, and she dove on top of him as they were going down the steps, and he kind of caught her and he kind of got her off of him, and then she called the cops because she hit her elbow, I think it was, on the wall. But they were like, yeah, you attacked her. And he's like, bruh, if you just look at the wall and look at my back, you can tell. They were like, but he was, like 6'9", and they were like, nah,
But you see how that
attacked her.
goes. But you see how that goes, right?
Yeah.
So now he's convicted of accidentally hurting somebody in the process of defending himself and/or trying to get away. And this is what happened in this case. And
No,
it's
terrible.
mind blowing to me. And I think that was really bothering me more than anything is how this could be anybody and how it set a precedent for people that don't have the means that he has to have to basically have their lives swept up from under them, because your everyday job, unless it's working for somebody that you know and they don't really care, or if they know what it means and it is not bothering them, you're going to lose your job. Or if you don't lose your job, any new jobs you try to apply for, if that pops up, they're not going to hire you, because in their mind, violence, abuse, they don't look at the nuances and what actually happened. They're not going to run tape. They're not going to look at the court transcript. They just see assault. They just see harassment. They see they don't want to hire you. So
which
now
is why the lawsuit.
at Walmart, from working at PricewaterhouseCoopers, now you're working at Walmart for the next 7 to 10 years until it doesn't show up on your 10-year rap sheet anymore.
And that's why I tell my clients, the story you tell is the one that gets told, because they're very rarely going to go over there. So we just got to figure out an elevator story, the elevator speech on what happened. So you got arrested for drugs. I've had a client arrested for drugs and some other serious stuff, and then we get it dismissed. And they go, what do I tell my employers? I said, you're gonna tell them that you were riding with somebody, you didn't know what they did, because they got arrested with a co-defendant. You were riding with somebody, you didn't know what they did. They had drugs, didn't tell it, but when we went to court, they realized it was their drugs, and they dismissed your case. That's the story you're gonna tell, because nobody's gonna dig down in there. I mean, that's the story that was. I'm not giving them a lie. I'm giving them a perspective on the facts that looked at that based on what they told me. I'm like, this is a perspective, which is why he doesn't have that benefit, because of the public trial. So even if it gets reversed, he still has that public record out there. And so I feel like, and this, they have probably people more qualified than me, because I'm the guy that's like, shit, we fighting. What time we fighting? I don't want to fight you, but if you say 3 o'clock, I'll be there at 2:55. But
greased up and ready to go.
Yeah, I mean, I don't want to fight. I choose nonviolence, but if you want to choose violence, I'm real good at that too. So let's go the peaceful way. But I think he would have to sue her for the admitted conduct, so that there's a complete record out there, or he can just go with, they made a preference, it was racial. He could probably have other people out there on his behalf pitching that and asking that question: how can it be retaliatory and true? Retaliatory implied false when in fact it was true. So he either has to have that. Yeah, that drum beat's got to be pounding and be out there, that has to stand on its own, or he's going to have to pull the Johnny Depp, and I'm going to sue you. And I may never get a dime from this money, but everybody's going to hear how you beat me. And now everybody's going to look at these little misdemeanors in perspective and be like, no. You know what? I don't know why they just charged him. And so people can see the injustice. You got to let people, when people see the injustice, that's the best evidence, as opposed to me telling you of the injustice. Once you see it, you're like, you know what?
That makes sense. And why? Yeah, exactly. But a lot of people already know this. But again, we're in the age where everything has to be televised or put in a PowerPoint presentation for it to stick. But all this stuff everyone knows. We know she got arrested. It was in the news. We got a picture of her doing the perk walk. We got the whole thing.
But the verbal people are the ones who are going to make the biggest stink, are the ones who are a little bit unhinged, and they're going to be like, how dare you bring this abuser in there? It's like, abuser? Let's dial this down a little bit. But
right.
they'll be doing the letter writing campaigns and writing 50 letters themselves, all with different names on the letter, because
right.
that's what they do. And so how, people, the squeaky wheel gets the oil sometimes when it's only one squeaky wheel amongst thousands, but still people are going to do it. So that's why I say you got to have that there and give people that you want to hire you some cover, or even if you don't litigate it, it's out there where they can kind of go, we really look at it. And he paid his debt. He did some counseling. He did some other stuff. And we also have to factor in the toxic relationship and the fact that there was some discrimination that went on, because why wasn't she charged? And we can't ignore that fact for conduct that she admitted. So if we're going to be fair, we're going to have to be fair, but we can't throw away a man under these facts. We can't throw away anybody under these facts. And everybody is entitled to redemption, or so I thought. And it's not like we're asking him to be redeemed from murder. I will point out, what's that? Marky Mark, one of those Wahlbergs, and were they involved in something?
Yeah, he went to prison for attempted murder of, I think the neighbor was Vietnamese, so at the time he was a racist. I don't know, he's not anymore. I guess he's a reformed racist. Yeah, but at the time he was a racist, and he beat the neighbor. Like, the guy's blind and everything as a result of it. He went to jail for that. And then he also was convicted of some other racial incident against a black kid.
And all I'm saying is, I don't say it to bring him down. I say it to show that the studios believe in that redemption story, and they allow that redemption story. So what is it going to take for them to allow this redemption story for less egregious conduct? So I don't want to bring up his past, the Wahlberg. I'm not bringing up his past to say he got a free pass. I'm not saying that at all. I'm just simply saying that redemption is out there for everybody. And it just seems to me that if it's out there for everybody, why is it that only somebody's are getting it? You know what I'm saying?
That
we all need to get it.
Since the Funky Bunch. I want to say about as soon as he got out of jail from damn near killing that neighbor, he became Marky Mark and had the Funky Bunch. So yeah, he got a hell of a pass.
Now, and I just, like I say, you say pass, I say redemption. He worked his way back, and I give it to you, because I'm going to get the same path that everybody before this man got it is the same path he gets to walk. So if that was redemption, he gets to walk redemption. Alec Baldwin did his stuff, he gets to walk redemption. We can go through the list of people who've done stuff that are now, beloved. Heck, if Roman Polanski, convicted and all that, can get a actual broadcast television award celebrating him with all of these people who claim to be woke celebrating him, if he can get that for sodomizing an underage girl, this man can get redemption. But I'm gonna need them to tell me why he can't get redemption. I mean, I know why they're gonna be fighting against it. It's the same reason that, when you look at him and you look at me and you look at you, we know the reason is skin deep.
Exactly. All of these things are the same. And one of these things are not like the other. And that would be
exactly. I mean, this is like minor compared to these major things, and yet here we are. So the path to redemption is there. He just got it, and maybe his path may actually not be the one of fighting to say treat me right, but he may have to go another path of contrition to redemption, which is probably easier to do. Because everybody loves a good contrition story, and just like, hey, I can still tell you how wrong I was done, but you know what? I have to recognize the wrong that I did, and I own my part in it. And I can't say enough words to you that's going to convince you, because if I convince you, the next person might not be convinced. And there are millions of people that I would have to convince, and I can't do that. I can only tell you in my heart, I've made the changes, I've done the work. I went to the class, the seminar, I spent 30, 60 days with somebody who's prominent and let you know he can work a way to get back on that path, and then say, I paid my dues. So by season 3 of Loki, if it comes back with a season 3, he can still be in the film, because
he who remains.
Because I thoroughly enjoyed his character, and I don't think that he needs to leave because of that, because there's too many other people out there that don't look like us who have walked the path and don't seem to have lost as much.
Right.
At all.
Did you watch Lovecraft? You'll love Lovecraft, especially if you're into like historical stuff. It's and science fiction. Lovecraft is really good.
I do like history because I was a history major.
Okay, so it's all history: 1950s Korean War, segregation. You know, that whole they touch on all that.
I got you. I love history, but I am a science fiction and that's all I really watch is science fiction and comedy.
Okay, so it's very heavy on the science fiction.
And I'm going to watch it because I meant to watch it when it was out, but I like it when I can binge watch stuff, so I can just go from start to finish, and I'm like, I got it. I love that.
It's heavy on the science fiction. The first minute of it is science fiction. It's spaceships, aliens, and the first maybe 5 to 10 minutes of it is that, and then.
Wait. You sold me because you just have no idea.
No, it's really good, and I'm not a big science fiction person because when I saw that first that intro, I was like, oh my god, I'm not watching this. But then it's a good mix of all. It's probably 60% science fiction and 40% historical / message, kind of stuff.
Okay.
I like the message stuff.
I have to deal with that because I be like, I don't listen like no 50s stuff. But I'm like, oh, black folks getting beat up and lynched. That makes me feel something.
The good thing is none of that. It's none of that. It's us doing what we probably should have done had we been braver. So it touches on all that stuff, but we're kicking ass. Like we're not the victims this time.
But anyway, I think that there you have it. I think that Mr. Majors he'd be better off with the underlying claims of assault and battery, not trying to litigate the interference. Because who cares if you lost that woman and she could bite you in the butt? Go with the easy win. And the easy win is she admitted to doing it. I can prove that. Let's go with that.
Right. Okay. Got you. But that's fair. Like I said, I'm gonna stick by it.
I know you ride or die. You with it.
I feel like I'm an advocate of just throwing everything out there. Again, you don't want to come across as that attorney that's just grasping at straws, obviously, and that's why a lot of attorneys decline certain cases because it's like you're not gonna have me out here looking crazy. But I feel like if we can find out for sure that she said things that were not true, using that part of the transcript where she said that Priya did not know what she told her versus what he told her, we might have something, Kirby. I don't know.
But we need Priya to say that though.
Right. We have to get Priya to say that. And so
and Priya might give and might take away. She might be, I had suspicions. I thought that Priya could open up stuff. I heard other stuff. And you're just like,
in a situation like that, though, don't you, before you even take because if this is a defense witness, you're going to talk to her before you put her on the stand. And then that's going to tell you whether or not you want her on the stand. So if
you got to have her, though. He's got to have her.
So no matter what, you got to have her.
Yeah, because you're basically saying, based on what you told her.
Start a show.
Yeah. So, and he's got to start with the falsity because without the falsity, you're not even playing the game. We can get on. Independent of any other elements, and putting aside collateral estoppel and putting aside immunity from the trial, putting all those aside in the universe that we're existing in under the hypothetical that we have now, the fact remains that you've got to prove falsity. And if she told her true statements that she did not know, that means you just now learned some true statements. And if you make a decision based on those true, if I didn't tell you to drop him. I didn't say fire him. I didn't say let him go. I just told you true statements. And then you using that and your own issues. I got other businesses. I got other clients. I don't want this. I don't want the trouble that you bring. Right. That is not going to be actionable. Or the worst case scenario, Priya says, she told me stuff that I'd heard before about him. I already had issues with this man before. I heard rumors about it. He and I talked about it or whatever. I say, hey man, is anything going to come out and bite you? And he told me, well, some things happened with, some women in his life, in his past, did make some statements. I didn't really pay close attention, but I heard enough about them to kind of go, they were the type statements that that anyone could go, I heard this. And then when this came up, I was like, that's it. I'm sorry. I gave you a chance, but it was not so much her as it was the other stuff. So that's what I'm saying is that's not the strong case because independent of, even if you could prove false, you can prove false. great, but you didn't encourage me to take any action, and it was that plus some other stuff. Now, if she just says, no, you know what? I believed her whole hog. She came in, she laid out this entire fact pattern for me, told me all these things, none of which she testified to at the trial. And it was I don't know what I fired him because she told me, like I said, gun to the head, knife to the throat. And that's why I fired him. Well, now you really gonna be more in the defamation category and all of that, but he's just gonna lose money on that because his whole goal is to win and then tell everybody I won. And now but where does it get it? That's why you got to start thinking strategically.
It's in redemption. I mean, I think that them releasing all that video and audio before the verdict even happened was redemption enough, because the overwhelming majority of people are still shocked that he got convicted of what he got convicted of.
Which is why the best redemption story for him is, if he, putting aside litigation, put aside that for a minute, just go, I had to recognize my role in it. That's
and
just
he did that on the ABC News. You got to watch that.
Well, I'm hearing now from you, because it's kind of interesting that I guessed a lot of the stuff that he would have said. I did not watch it.
The playbook was heavy.
Yeah, but I think that what he needs to do is own his part in it, and not from the perspective of, I hate that I stayed there so she could get me in trouble. That's not going to wash. I had to own the parts of what role I played. Yeah, you don't got to tell anybody what. Yeah, you don't got to tell nobody what your role is.
Not breaking up with her. He's like, I should have been brave. I should have broke up with her.
I didn't go brave. I should have been decisive. I should have been decisive. I should have recognized that her and me together weren't a good combination. You know, that's just a fact. She has her issues, and I'm not here to trash her, because obviously for a match to strike, it's got to have something to strike against. So, you know, so I got to acknowledge that fact. So I acknowledge my role in the process. I do acknowledge we can't ignore the fact that there was some double standards and some other stuff going on there, but independent of all the injustice that happened to me, and I think there was a lot of it, I do have to acknowledge that I also played a part in that, in terms of what I did, my depression, my anxiety, my temper, my being, you know, some of the stresses. I got to understand. I got to understand that, you know, just because that's true doesn't mean that I am relieved of certain obligations as well. So, and again, not detailing in particular. So you got to make sure that you don't get some reporter tell me specifically what you did. And I'm not going to do that, because no matter what,
her at all, which was good.
But that's what I'm saying. And then just kind of go, I got to own my role, but I'm not the ogre that made me out to be. But I did play a part. And then talk about what you've done since that time to make it. I went and sat and listened to women who've been the victims of abuse, you know, and I listened to that. I went and sat over here to households where abuse happened. I went there. I went through all of that. I went through the whatever things you had to go through, just to say, forget what I say is true. Forget any of that. Let me just acknowledge that I was here, and I had to take a determination to ask myself, am I going to sit here and just scream at everybody and tell everybody how I was done wrong, or own my part in this and learn from it? Exactly. And if you do that, I think America always seems to love a good redemption story, especially when you're not really the ogre that, I mean.
And prior to this, you had no issues prior to this. Nobody put your name in a negative light prior to this.
Exactly.
So why are we acting like your recidivism rates are so high that we can't, this is just the straw that broke the camel's back? What?
No, exactly. I mean, and it's just a business decision. Own it, and the further away from it you get, the more vocal you can get about the bull crap that was done to you. Like, you know, 10 years from now or 5 years from now, it's going to, you know, assuming he's done the redemption tour, and then he can be like, well, you remember you did this? Well, let's not ignore the fact that, and then he can bring you in and just start firing off stuff. Well, you said, no, I learned lessons, but let's not act like I wasn't done wrong. I just figured, since I was there, you know, while I was a slave, I learned to read. You know what I'm saying? You know, that's all I'm saying.
I learned to read, and now that I know how to read, I'm gonna tell you what. Yeah,
exactly. And I'm now gonna tell you what that Constitution that y'all been talking about. For some reason, I don't see those rights applying to me. But I'm just pointing out that, find out where you are, and then the further away you get from it, you can talk trash. You know, you know, and there is that letter. Oh, I can't remember. It's a letter from and I hate to be using the slave metaphor. I'm not trying to compare that. So lest anyone get upset with me for using this comparison. Just it's the only thing I can think about right now.
They better know they come on this page, anything goes. So.
Yeah, pardon my ADHD, but in this one, it was a slave who had, I think, gone to Illinois or Ohio or somewhere, and his former slave master wrote him a letter saying, "Come back." And he wrote, and he wrote a letter back, or at least somebody on his behalf wrote a letter back, and it was like he was hardcore on that man, just going in on it.
I did see that. Yes. Yeah.
And I'm drawing a blank on the name right now. I can't think of the name, but it was an amazing thing. And my point being is that once you are in freedom land, you can talk all the trash you want to. Like, yeah, let me tell you what you did. Let me tell you about yourself. Let me tell you about your so-called justice system.
Jordan Anderson.
Is that it?
A letter from a freedman to his old master.
There you go.
Yes, I remember that.
And see, I was going to say Jordan Peele.
Ladies and gentlemen.
Yeah.
So look that up. It's a letter from Jordan, Jourdon Anderson. The letter is called A Letter from a Freed Man to His Old Master. It was written in 1865. And then read that, because it was a good analogy, because that can apply to everything in life, whether it be a job that you hate, whether it be a relationship you need to get out of, that you might have been afraid to before that point. That letter is that's a perfect analogy, Kirby. I remember that, and I knew what to Google. That's why I found it.
Okay, and I was like Jordan Peele. I'm like Jordan Peele. I'm like no, that's the actor.
Yeah,
no,
I remember that one. Yep.
Yeah.
Yeah.
There you go.
But thank you so much. Anything else you want to say before I put up your information for your law firm? Once again,
I'm good.
I'm trying to push Kirby out of his comfort zone. He is still licensed in New York State. So if anyone has any issues that need a defense attorney in New York State, just let him know. I fly up there whenever you need me to do any due diligence for you, Kirby. I'm good. I got flight benefits.
All right.
But
still in Georgia too. Don't forget now.
Yes, he's still in Georgia. This is his Atlanta firm information. If you look, there's the website. Is the address correct? Because that was on the website. Oh,
it's still on the website, man. It's got to get changed. I thought I changed it. That goes to show you what I get trying to do web design. It is.
I'll hook you up with that. I can do that for you. But the phone number is correct, right?
Yes, phone number is correct.
Email is correct. The website is correct.
Yes.
So I'm sure most of you are not going to drive by there randomly. So call them or email them or go to the website for the time being. But he is in the Atlanta metro area, obviously licensed throughout the state of Georgia. So, I mean, I'm sure, if the case is, serious enough, he'd be willing to venture out. But this is the law office. Again, Kirby does criminal defense. What other type of defense?
We do personal injury, and I actually do consumer debt defense. When you've gotten sued by a collection agency, I will defend those lawsuits and car repo lawsuits.
Okay, so there you go. So you got your car about to get snatched out the driveway. Call Kirby. You got creditors abusing you and robocalling you despite you asking them to stop. Call Kirby. Creditors that are trying to put judgments against you and it might not be rightful. Call Kirby. Credit reporting that is not, ethical or correct. Call Kirby.
If you're going to jail or been hurt in a car wreck,
call Kirby and his sister. They do all that personal injury stuff as well. But this is their information. Thanks again so much, Kirby, for joining me again. I will figure out what we can talk about next, or what,
right.
Overly ambitious lawsuit I come up with next. And then we can have another discussion.
Absolutely.
But, give Kirby a call. Thanks again, Kirby.
All right. Thank you.
All right. Bye-bye.
Bye-bye.